Welcome viewers to part 2 of my review of the LegalZoom Internet Will and Trust Preparation Service. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman Mizuko. Keep in mind that I'm not affiliated with LegalZoom in any way. Also, I'm not associated in any way with any lawsuits against LegalZoom. I'm an attorney who has been involved with computerized document assembly systems since the 1980s. I've written several estate planning systems myself, and I decided to review LegalZoom merely because I'm interested in the topic. In part 1 of the review, I went through each step of the LegalZoom online interview process from logging in to completion. As part 1 ended, I finished the interview and I was waiting for my will and revocable trust agreement to be delivered by mail. Here's a summary of part 1 of the review. First, the LegalZoom site is well organized and easy to navigate. Second, LegalZoom provides access to some good, easy to understand basic information about wills and trusts. When evaluating LegalZoom, however, keep in mind that similar information is available online for free. Third, although LegalZoom is less expensive than what you would pay an estate planning attorney, it's not cheap. I paid $349 for an estate planning bundle. That's a lot to pay if there's a risk it will not give me what I need.
Fourth, LegalZoom's terms of service and terms of use agreements say that if something goes wrong, I accept the risk, and my beneficiaries and I will have no recourse against LegalZoom. LegalZoom accepts no responsibility.
Fifth, LegalZoom frequently prompts the user to make decisions about questions before the user has sufficient information on which to base his or her decisions. This creates a significant risk of misunderstandings and mistakes. Sixth, LegalZoom offers very little guidance regarding tax planning. Seventh, I've been asked whether LegalZoom is appropriate for the average Joe. It may be, but there's no procedure for separating customers who might be the average Joe from those who are not. There's no effort to probe with follow-up questions or to alert the customer to problems. In my experience, the average Joe is rare. The failure to probe deeper into the customer's situation and to make an effort to alert the customer to problems is, in my opinion, a serious defect and creates a significant risk of unintended and unfortunate results. That was on June 18th. After a couple of restarts to the LegalZoom system, which I'll try to explain later, I received my will and trust agreement by mail on July 13, almost a month later. Here's the box it came in, and when I open the box, this is what I see. Unfortunately, on this very impressive looking leathery cover, I see the name of my trust is misspelled. Instead of Richard S. Land Trust, it says Ridhard S. Land Trust. I'm certain the typo is my fault, my off-target keystroke, but as mentioned in part 1, LegalZoom did promise me what they call a peace of mind review, which is supposed to catch this type of thing. I understand this type of thing can easily happen, so I try not to let it bother me. I'll talk to LegalZoom about fixing it later. So let's take a look at the documents. The first document I see is a bill of transfer and notice of assignment. And then I see forms to help transfer assets to the revocable trust. I'll talk about them later, after we take a look at the trust agreement and the will. Then I come to the declaration of trust. I won't go over every provision. What I want to do is focus on any problem I see. The first problem I see is something I already covered. It's the name of the trust. It's misspelled. What should be the Richard S. Land Trust is spelled the Ridhard S. Land Trust. Ridhard with a D. I'll call LegalZoom and ask about correcting that later. Different attorneys have different ways of doing things. I won't comment on relatively insignificant differences in style or substance. What I want to do is focus only on portions of the document that may represent a significant flaw. I don't see any important issue until I get to section 6, which identifies the beneficiaries. In that section it says that 25% is to go to my daughter, and if she's not living at the time of my death, that 25% is to go to my son. To me, this is a big problem. You may remember that in part 1 of this review, I tried to insert language that said if my daughter does not survive me, I want my daughter's share to be paid to her children or her descendants. That language was rejected by LegalZoom. I called LegalZoom to ask why and was told that I'm limited to only one alternate beneficiary for my daughter's 25% if she does not survive me. I believe this is probably a big problem for 90% of people who want to name their children as beneficiaries. They usually want the child's children to receive the deceased child's share. So if your deceased child has more than one child, the LegalZoom document will probably disinherit one or more of your grandchildren unless you can get LegalZoom to change the document. The same problem exists for the 25% payable to my son and for the 50% payable to my wife. LegalZoom allows only one alternate beneficiary for each. I intend to call LegalZoom about this to ask how I can solve what I consider a problem, but I wonder how many people are accepting this format without any question, and how many children and grandchildren will be disinherited by mistake as a result of accepting this format. In my opinion, this is a major flaw which creates a substantial risk of the LegalZoom customer disinheriting individuals to whom the customer would want to provide an inheritance. The next issue I believe is worthy of a comment relates to the terms of the trust established for my children. In part 1 of the review, I indicated that the 25% payable to each of my son and daughter should be held in trust until age 50, and I mentioned that the standards for distributions from the trust are health, education, maintenance, and support. I also mentioned that this is a common standard, but that it can have an impact on the beneficiary's eligibility for education aid or public assistance, which perhaps the customer should know about before signing, especially if the beneficiary has special needs related to a disability. Here is the health, education, maintenance, and support language I was talking about. There is nothing in the terms of the trust to attempt to deal with the possible loss of scholarship aid or public assistance that the health, education, maintenance, and support language can cause. And there is nothing in the LegalZoom computerized interview to suggest that the LegalZoom customer might want to consider the issue. In part 1 of the review, I mentioned how naming trusts as the beneficiary of certain retirement plan accounts can create some very costly income tax problems. I said that I'd be on the lookout for trust provisions in the LegalZoom documents that try to deal with the problem. Unfortunately, there are no provisions in the LegalZoom documents to try to maximize the income tax deferral features of such retirement plan accounts. Rather, payment to the trusts in the LegalZoom documents probably would require payment within the 5-year rule. That's approximately 5 years after the account owner's death, resulting in what could be a very costly acceleration of the payment of income taxes. Now, let's leave the trust agreement and go back to the beginning when we saw documents purporting to change ownership and beneficiaries. Notice that the transfer documents purports to transfer the proceeds of an IRA to the trust. If this were an effective transfer, this would be a big mistake because such a transfer would make the whole IRA taxable when the transfer document is signed. But in fact, this document probably does not transfer anything because the transfer probably can only be effective if done with the forms of the IRA administrator and if accepted by the administrator. LegalZoom provides instructions regarding how to make transfers. In the instructions, LegalZoom says some of the financial institutions may have their own forms. That's an understatement. You should assume that all the financial institutions you deal with will have their own forms and that any attempt to make changes using your own forms or LegalZoom's forms will probably be ineffective. Always try to use the form of the financial institution. Also, at the risk of repeating myself, keep in mind that retirement plan accounts are different from other accounts because usually they have not been subjected to income tax.
Making a mistake naming the beneficiary of the retirement account can result in severe income tax consequences, which I have already mentioned. Here you see such a mistake. LegalZoom has prepared a document naming my trust as the beneficiary of my IRA. That means that at my death, the full balance of my IRA will be subjected to tax according to the 5-year rule instead of achieving substantial deferral of tax over the lifetimes of my children.
After many weeks, I finally got around to taking advantage of the attorney consultation which is provided as part of the fee I paid. I made the appointment online at the LegalZoom website. A time was scheduled when the attorney would call me, and he called on time. I spoke with him for less than 30 minutes. I had 3 issues on my mind that I wanted to discuss. The first issue was how to correct the name of my trust. As mentioned before, the name was misspelled. I wanted it changed from the Ridhard Land Trust to the Richard Land Trust. The attorney told me that he could not change the document. He could only help me understand the terms of the document and try to answer my questions. My second question related to how I was limited to naming just one person as a secondary beneficiary. Previously, I mentioned that I named my daughter as my primary beneficiary, and I wanted to name her children, and that's more than one child, as secondary beneficiary, but that the LegalZoom format would allow only one name as the secondary beneficiary. He said he could not change this for me and that I should talk to LegalZoom about changing it. I told him that I had already talked to LegalZoom and was told this was my only option. I asked him if I could get my money back because the trust as drafted is not what I want. He said that he had no authority to make that happen and that I should talk to LegalZoom about it. He also made an attempt to tell me that the trust had to be prepared that way because of something called the rule against perpetuities. I was very surprised when he offered that as an explanation because it's just plain wrong, but not just wrong, it's rather breathtakingly wrong. Lastly, I wanted to get my attorney's take on the income tax rules for retirement plan accounts. He was fairly good in that question, but he did misstate the rule. He described an older version of the rule related to minimum required distributions instead of a more recent and usually more favorable rule. So that was my experience with the attorney consultation. I asked my attorney to deal with 3 issues, and he failed to satisfy me or give me good answers all 3 times. That completes my review of the LegalZoom estate planning system, and to conclude, LegalZoom has some very significant drawbacks and the buyer should beware. For more information on estate planning and estate settlement topics, you may be interested in the videos listed on the slide which I have posted to YouTube. Thanks for watching and goodbye.